Many Arizona real estate exam questions about property ownership are designed to test whether you understand how ownership transfers when someone dies, not just who owns the property today. Welcome back to Property Professor's AZ Real Estate Exam Series. In this module, we're covering the most common exam traps related to property ownership and estates. Let's begin with tenancy and severalty. Severalty means ownership by one person or one legal entity. Despite the name, it does not involve multiple owners. It simply means the property is owned individually. This is the most straightforward form of ownership. Now let's move to tenancy in common, one of the most tested ownership structures. Tenancy in common allows two or more people to own property together, but each owner holds a separate interest. Those interests do not have to be equal. One person could own 50%, another 30%, and another 20%. The most important rule to remember is this: tenancy in common does not include a right of survivorship. If one owner dies, their ownership interest passes to their heirs, not the other owners. Now let's discuss joint tenancy. Joint tenancy also involves multiple owners, but it includes something very important: the right of survivorship. When one joint tenant dies, their ownership interest automatically transfers to the remaining joint tenants. This transfer happens outside of probate. To create a joint tenancy, 4 conditions, often called the 4 unities, must exist: unity of time, unity of title, unity of interest, unity of possession. A helpful memory device is TTIP: time, title, interest, possession. If those 4 unities are not present, joint tenancy may not exist. Now let's talk about community property, which is extremely important in Arizona. Arizona is a community property state. This means that property acquired during marriage is generally owned equally by both spouses, regardless of which spouse earned the income. Community property typically gives each spouse a 50% ownership interest. However, Arizona also allows a special form called community property with right of survivorship. This combines community property rules with survivorship rights. When one spouse dies, the surviving spouse automatically receives the property. Without survivorship, the deceased spouse's share may pass through probate. This distinction appears frequently on the Arizona real estate exam. Now let's review a quick comparison. Tenancy in common, multiple owners, unequal shares allowed, no right of survivorship. Joint tenancy, multiple owners, equal shares required, includes right of survivorship. Community property, applies to married couples in Arizona, typically equal ownership, may include survivorship depending on how title is held. Exam strategy tip: when you see ownership questions, immediately look for keywords like survivorship, heirs, or married couple. Those clues usually reveal the correct ownership structure. In the next topic of Property Professor's AZ Real Estate Exam Series, we'll move into encumbrances, liens, and property restrictions, another section that Arizona tests consistently. If you're serious about becoming a licensed real estate agent in Arizona and want mentorship beyond just passing the exam, connect with me. I'm building a team of well-trained professionals who want to build their careers the right way. Take care.